Uh, Welcome back to the House Judiciary Committee this Wednesday afternoon, March 11th. We are now turning our attention to H772, and just a really quick background before I have Cameron walk through it. What we have, it is an amendment, a proposed amendment at this point by me. I worked with Cameron and also read this by Jeff Tony and Eric Fitzpatrick, and it tried to address some of the issues that were brought up by one of our main witnesses and main stakeholders in this particular issue, because we're changing around court process. But I worked with the court, and this is what we have, and hopefully it gets closer to at least being okay with the court. Don't know where the tenants and landlords will be with it, but we'll hear from them on this. So over to you, Cameron, with that.
For the record, Office of Legislative Counsel, Cameron Wood, is going to walk through an amendment. As Mr. Chair, you mentioned, this is currently drafted from the chair. Share my screen and we'll get going. Okay. So draft amendment, what I've done here is I've tried to highlight areas where this is going to be slightly different than the proposed language that came out of the House General and Housing Committee. So all of these changes are related to the ejectment process, the court process for ejectments, the trespass provisions, or the confidential nature of the ejectment records. So if you remember from our walkthrough prior to your break, you have all that language initially around residential rental agreements and the changes that are being made there and the changes regarding termination notice, et cetera. There's no amendments to that language. So the first amendment is going to be in this section 2. Well, BSA 663, this is new section, new language. So before I walk through this amendment, I'm going to bring you back to the proposal from the House General Committee. So this was the proposal coming out of House General, which was allowing, if you remember, this was allowing the TAC orders. And if the court orders alternate service of process, then that would last throughout the entire court proceeding. So it was also not just limited to ejectment cases. This was for all civil proceedings. And there were some concerns that was raised about whether or not that was appropriate to allow that alternate service once and then subsequently allow it throughout every service that's required in a case. So the amendment here strikes that first subsection A. So it's not going to authorize that alternate service throughout a case. An individual could still request an alternate service of process at any point in a case. So it's not making that in statute where if it is authorized, it can exist throughout. The language that is here, though, the proposed amendment keeps what was a subsection B, and it says when a motion for alternate service of process is filed in an action brought under 10 VSA 153, 11 Chapter 14, or 12 VSA Chapter 169. So those are the different ejectment that can be brought depending on the housing circumstance. The 10 VSA Chapter 153 would be an ejectment for a manufactured home and a manufactured home park. 11 Chapter 14 would be ejectment when there is a cooperative housing organization. You need to eject a member of the cooperative housing organization. And then the 12 VSA Chapter 169 is the ejectment that we've been walking through and is in the bill, ejectment for a tenant in a residential rental agreement. The change here is that it would apply to just those. So that's why I added ejectment here in the section heading. And then it says rule on the motion promptly. And if you all recall, the proposal from the House General Committee was 3 days after that was filed. And there was concern, testimony from the judiciary about that turnaround. And so the recommendation here is just to go with rule on the motion promptly. That's the first amendment. The second amendment here is a strike through of the ejectment section. So section 3, which was dealing with that new ejectment process that's being proposed by the House General Committee. So it's just striking out that entire section, and we're adding a lot of the language back in with some tweaks. So I'm not going to walk through every single provision here because we walked through it last time, but I will highlight the changes that you have. This section is about asking when payment of rent into court. So the landlord has brought the ejectment action against the tenant, and they're asking that while the ejectment action is ongoing, that the tenant be paying rent into court. And if you all recall, the proposal from the House General Committee here on subdivision D is to remove the ability to offer partial payment of rent into court. So it would require full payment of rent. The removal of subsection G is corresponding to that, takes away the tenant's ability to apply via motion to reduce the amount. So that's all kept, but there's this new subsection I, which states that if the parties come to an agreement, then the parties can apply by motion to the court to have that amount reduced. So going with the proposal from House General to default to full payment of rent into court, but authorizing the parties to come to a separate agreement and request a motion for that. Now we're moving into this new subchapter 4. So I'm on page 4, moving to page 5 of this proposed amendment. So again, all this language is keeping what was proposed by the House General Committee. The only changes are highlighted yellow. And that begins here where we get to the mode and service of process. This is where the rental agreement and the notice to terminate has to be included as part of the complaint. And if you recall, way back in the residential rental agreement language, it requires a notice to terminate based on the breach of the rental agreement. It requires there to be an affidavit with particular facts that's given to the tenant. Judge Zone had pointed out that it wasn't clear that that affidavit going with the termination notice had to be part of the complaint. So the line 7 and 8 here is really just fixing that to ensure that that information is also coming along. And then we get into lines 12, 4, 8, 6, 3. This is, there was an initial sub A that required the answer to be provided within a specific time frame. I believe it was 14 days, I think, as coming out of the House General Committee. And we discussed that that is different in your rules of civil procedure, which an ejectment action is a civil case. So it would be applying a different timeline there. So this proposal would remove that. So the tenant or the defendant in this situation would have 21 days to file an answer as the individual would in any other civil case. That's the first change there, is just striking that requirement of the 14 days. And then when we get to page 6, there's this B1, which exists, was about the cure. And it states that, the party, the defendant has the right to cure, but loses that right as a matter of law if it's not done by the answer date. And there was concern about if that language were there, would that somehow prohibit the parties from coming to some sort of agreement after that period? So there's just some language that's being added on the top of 6 saying, notwithstanding that sub 1, the parties can at any time prior to the issuance of the writ come to an agreement to cure. So wanting to make sure you're not precluding those settlement negotiations ongoing during the case. Now we get to default. And there was some language that was proposed by the House General Committee that just appeared to be in somewhat conflict with the current rules related to when the default, there's a rule that governs this. And so the first 2 instances of amendment on lines 10, 11, and 12 are just stating that if the defendant fails to file the answer in the time prescribed in the rule, the plaintiff can file a motion for a default judgment as the plaintiff is authorized in Rule 55. So again, the amendment here is really just wanting to keep consistent with what your rules of civil procedure authorize in other civil actions. And then The other change is there on line 13, the court shall rule on the motion promptly. And I could look it up. I don't remember off the top of my head exactly when it was in the underlying bill, but
You said something like 5 days, 3 or 5 days.
yeah, yes, sir. So again, just going back to the recommendation from the judiciary about getting away from those specific dates and time and going with promptly here. This next section, 4865, there, if you remember, there was this language about having a show cause hearing if there was an ejectment brought under the subdivision 4467B for breach of rental agreement, and if it was for kind of threatening behavior, you could have this show cause hearing where it would have to be within a specific time frame, and you could offer affidavit evidence. And then if the judge felt that there was live testimony necessary, you would then have another hearing. All of that has been removed. And what you have here is under the current ejectment subchapter that exists, there is an expedited hearing process when there is an unlawful occupant of the premises. And so this is really just mirroring all of that language that currently exists in statute. So instead of creating this new show cause hearing process, it's just saying, if you're bringing an ejectment under, right there on line 16, the 4467B2, because the defendant is doing some action that is threatening the health or safety of other individuals, then there's going to be this expedited hearing that is based off an expedited hearing that currently exists, and we're going to follow that process instead. One change that I would comment is in the sub B on page 7, starting with line 3, trying to keep some of the time frame that was built out in that show cause hearing. It does state that a hearing on the motion for this expedited ejectment shall be held promptly at any time after 10 days notice to the parties, but not later than 21 days after the motion is filed, absent good cause. So there is a little bit of a deadline in there for the courts, recognizing the nature of this termination is due to some sort of accusation of threatening behavior. So wanting to have kind of an expedited process here, or a more expedited process here. I'm not going to walk through each section here because it is mirroring what is currently there, but this just, sets up the expedited process, allows the defendant to oppose the motion. With the sub D here is if the defendant fails to appear or file the affidavit, then the plaintiff is entitled to judgment by default and immediate possession. And then the sub 2 is if the court finds the defendant is a threat to the health and safety of others, the court grants the plaintiff motion to issue judgment in favor of the plaintiff for immediate possession. And then you have in the sub E is just when there is that issuance, it has to go to the sheriff and the sheriff has to serve it. And then not sooner than 5 days after the writ is served, put the plaintiff into possession. And that all, again, it mirrors the current statutory framework for unlawful occupant.
Well, what's the unlawful occupant citation?
Let me grab it for you as soon as I stop.
Okay, yeah, that's fine. Yeah.
Okay. So moving forward with the remainder of this, keeps everything else that was proposed in this new subchapter from the House General Committee for the new ejectment language. So now we get to the third instance of amendment here on line 6, page 9. If you recall, there was some new language in the trespass section under Title 13, and it would allow the landlord to issue a no trespass order to an invitee under certain circumstances. If the tenant consents, I don't want this individual on the property either. I'm consenting to you issuing the no trespass to the individual. If the invitee is violating terms of the lease agreement, or if they're violating state or federal law, then the landlord can issue the no trespass. There was an appeal in there. And if you remember, it was going to small claims, and there was discussion here in committee about whether it should go to Judicial Bureau. And so what this amendment would do is just strike that appeal section entirely. the underlying trespass section doesn't have an appeal rights to it. So currently, if you issue an individual an order against trespass, it doesn't come with appeal rights. It's the individual's property that you're telling you're not authorized to come onto my property. So the appeal seemed to just be a slightly alteration of the current way that the trespass section works. So this proposal would just remove that appeal. And then you don't have to worry about whether it goes to small claims, judicial bureau, et cetera. And then the last instance of amendment, the fourth here, is about the confidentiality of ejectment records. And there was some conversation about the language. If you remember it, when the ejectment action is initiated, the case becomes confidential, but then it loses its confidential status if it was to non-payment of rent or breach of rental terms, but it would maintain its confidential status for any other ejectment. And you all have had some discussion before break about the language is a bit quirky in the sense that it says that the tenant didn't have to notify someone that there was an ejectment as if it didn't happen, but it had happened, and there was losing confidential nature under some circumstances, but not all if a writ of possession was issued. So the proposal here was just to clean this up a little bit. And so it's if there's a writ of possession issued in favor of the plaintiff. So if the plaintiff, wins the case, gets the writ of possession such that the individual is going to be ejected from the premises at that point in time, it would lose its confidential status. So there's no distinction between, well, which type of ejectment did you bring? And then the amendment on line 15 is just clarifying that the court removes the confidentiality of the ejectment 30 days after issuing the writ. I believe the language that came out of House General was just it loses it after 30 days, and it wasn't clear at what point in time do you begin counting the 30 days. And so this is just clarifying it's after the writ is issued 30 days after that date, it would lose its confidential status. Those are the proposals of amendments.
Excellent.
And I have a few minutes if there's any questions.
Yeah, any questions? No, thank you very much. It was very straightforward. Here, and I no longer owe my first cow to the chair coordination. There.
I assure you, sir, I am not worth that.
Oh, come on! No, you haven't seen my first. I'm just.
I will be back. I'm going to go to Ways and Means, but I will be back shortly. So
thank you, Doug. All right, so we're going to go to Terry Carsone's next. Terry, thank you for being here.
Thank you for letting me go a little bit out of order. Judge Zoney was scheduled and he was appearing remotely, and I think because he had already addressed the version before break, he kindly offered to let me go first so that I could address basically two aspects of the proposed bill. And I will speak to the most current version that we received last evening. Thank you for the chance. Terry Carson, State Court Administrator. And I would like to address basically two aspects of the bill in general, one of which is the confidentiality aspect.
Yeah, and on that one, folks probably want to grab the draft number 4.1 that you have, because that's where you'll see most of the language. The amendment only changes one little part. So
in section 6, right, of that version. And there was one slight amendment, as Cameron mentioned, regarding that section in the most recent version. But I was going to address the confidentiality aspect of the bill in general, as well as the ramifications of not just the confidentiality aspect, but other aspects of the bill in general on court operations, in particular with respect to scheduling and significant impacts on scheduling capabilities because of the proposals. We do very much appreciate the modifications that have been made. I, in large part, do address many of the issues that were brought to light by Judge Zoney and others. But in terms of the confidentiality aspect of it, I just wanted to emphasize that a confidential docket would be highly unusual in our state court system. Currently, there are only two dockets that are confidential. That's the juvenile docket and the mental health docket. And those dockets have been confidential since day one for the sensitive nature of the subject matter and the privacy concerns for juvenile dockets and mental health dockets. So to isolate a separate docket as confidential would be very unusual and very contrary to the normal public access and transparency and open hearings that we have in our state court system. So I just wanted to highlight that in case that was something that people might not be aware of. We usually.
Question, if you can finish your thought, and then I just had a question about that. Or-
That's fine.
So you mentioned hearings, but my understanding, this would only be the records. The hearings wouldn't be closed.
That was, the closed hearings was in an earlier version, but not in the present version.
Right. I see it only applying to records, not being, and I think.
It was specified that hearings would be open to the public in earlier versions, and that's not in the current version. And because it describes all the court records, I mean, we assumed that the hearings would be confidential as well, because there's nothing that states to the contrary.
Yeah, I guess I had read it differently because it just said records, and we can clarify. But it seems more problematic, certainly, to have the hearings closed, a little less so than for some period of time having records essentially flagged on the system as not accessible. And I do have a couple of questions about that.
Okay, well, there was, if I remember in the early version, at least when we testified before general housing, that they indicated that that hearings would be open to the public.
Right.
And we did actually testify to issues that would be involved with that, because if it's people calling to inquire about a hearing, on the one hand, it's confidential, in which case we would say there is no case.
Okay.
On the other hand, oh, well, for the case that doesn't exist, the hearing's at Tuesday at 3. So there were definitely issues with it being open to the public, but there are also issues with it being closed to the public. And since that's my understanding of the present posture, I was going to address the issues with that.
Yeah, and I guess it was just ambiguous to me, and I thought the way I read it is that the hearings were not closed, but that's sounds like there's problems either way.
Yes, and I think it all stems from, again, this docket, which normally, and I don't know if it's confidential in any other court in the union, but it would just be very unusual. The problems with it being, the hearings being closed to the public as well, from a scheduling perspective, is we would, in essence, need to treat these cases similar to how we treat juvenile cases and mental health cases, and that is that we have separate courtrooms. You basically have to have a separate courtroom if the case is confidential to prevent people who shouldn't have access to the court hearing from accessing that court hearing. It also presents problems with flexibility in scheduling. Right now, landlord-tenant cases are part of the general civil docket. They're scheduled along with the other civil division cases. So you could have, a merits hearing, and then you could have a foreclosure hearing or, a breach of contract hearing all in the same day. With this, you'd have to separate it out, because you couldn't have a case that's confidential, lock the courtroom, and then schedule something. It just would be very, very inconvenient and problematic. So it would require a separate courtroom, in our view, similar to a juvenile separate courtroom or a mental health one, which means a separate courtroom operator, which would also mean a separate person, either a judicial assistant or a security officer, to kind of control who has access to the courtroom and who does not. That's what we do in the juvenile hearings and the mental health hearings. You'd have that aspect of it that would be, again, very unusual and very resource impactful, additional personnel and courtroom space, if you will. Also, in the smaller courtrooms, the civil division judge also hears criminal division, also hears family division. So they're set aside for this, one courtroom and not hearing anything else, on whatever the scheduling block is for that day.
So can I explore just a little further the concept of if it was open?
Yeah.
And what the issue is? That the issue is that somebody could contact the court and say, hey, I want to go to such and so hearing, and presumably you wouldn't be able to say anything. If this was narrower in some manner, that essentially the documents that are filed, not the existence of the name of the case or the plaintiff and defendant, but the files themselves are essentially sealed for the duration unless they're unsealed at the end. I'll call them sealed instead of confidential, but same thing. Is that still, I mean, is that good?
Well, I thought the purpose of making it confidential is that landlords wouldn't be able to ascertain if there's a hearing or a landlord tenant, or I'm sorry, an eviction case involving a potential tenant. So if you're saying just the documents are confidential, but the case name and its appearance on the hearing schedule isn't, it would just be very, I think, complicated and difficult for court staff trying to field and offer information for this kind of hybrid approach.
I guess I'm just saying, maybe I'm just trying to understand the actual logistics of this as far as if a case is filed electronically, isn't there essentially call the switch, something on that you can hit that this document's now sealed?
Well, not sealed, if you
Or
will, be confidential, yes. So for example, it wouldn't be accessible on the public portal.
Right,
Well,
right. That's what I guess.
okay, but I guess if we're talking about if the hearings were open to the public, we'd have that issue about, okay, how do you provide information in this confidential and not otherwise accessible? If it is open to the public, it's more, I guess, logistical problems in terms of necessity of a separate courtroom then, and to deny access to people who weren't a party, an attorney, or witness in that particular case. And even among several eviction cases, you wouldn't be able to mix and mingle the separate cases because each would be confidential in and of themselves.
So, I guess I'm trying to find maybe a path that's not there. But is if the court hearings public, the actual case name is public, but the complaint, the answer, the pleadings are flagged as confidential until the end of the case. My question for you right now is just, does that take care? I mean, yes, it's some logistical issue still. I will ask other witnesses if that gets at what they want at all, if that's just not even sufficient, but I'm just trying to get the logistical part.
Yeah, I guess, so if the documents are confidential, but the case name is not, you're saying, would that solve the problem? Yeah. I guess part would be to ask the others, well, how does that address their need to have this not?
Right, and that's.
Otherwise,
it's just.
Yeah, I
Does that
guess,
help the situation?
maybe it would in terms of being able to, I don't know. I'd have to kind of think that through to imagine. It just, to me, would be a very kind of unusual and complicated scenario.
Right.
For court staff and trying to address the usual questions that you get at the counter or over the phone regarding cases that are on the schedule or
Right.
in the docket.
I think Karen had a question.
You know, I was trying to find this piece of finding a way to have it work, because I think it is like there's both sides of it. But I didn't know if it could be, was me just putting out an idea of like
Yeah.
Wednesday mornings are landlord tenant things. And so like, you know, that it's going to be that those types of hearings, but there's not a listing of the cases. But folks would know, come Wednesday morning, that's when we're going to have these types of cases.
Right, but if you're in an eviction case A and there's an eviction case B.
Yeah.
And if they're supposed to be confidential.
Oh, no, we're saying if but they're open to the public.
Oh,
Yeah.
okay, so going
So
back
the
to
hearing,
that.
yeah, the hearings are
Okay.
public, but the documents are not.
Okay, but to have the documents confidential, but the name of the case not confidential. And then that's.
Because they would hear it in the hearing.
Right, and then post it.
Because is that a rule? It has to be posted. If you're having a hearing, you have to
If it's
post
a
too.
public hearing,
Okay.
yeah.
So maybe that's.
And also on the public portal, then there would be information about that on the public portal, but how do you do that if everything's otherwise sealed or confidential? I just think it would be very unusual and I think complicated. I mean, whatever ultimately results from this, we will work with.
Mhm.
I'm just wanting to point out that it's a departure
Yeah.
from how we've always done things, other than juvenile mental health, which have the very, I think unique and specific, sensitive kind of information. So for the confidential, I know there was a change also in terms of that if a writ of possession issues, then the confidentiality would cease unless it's talked about the court orders continued confidentiality. And I guess one consequence of that is what the standard would be.
And we removed that in the amendment though. Or is it? No?
No, it's in there unless the court orders continued confidentiality, but it would be a matter of under what circumstances would continued confidentiality occur. And I assume that would trigger, for example, a hearing. And one thing that I was going to mention in addition to the, just again, the unusual nature of the confidentiality approach and the complications that I think would ensue in terms of scheduling, is the impact on scheduling resources right now. Because there are a variety of additional hearing opportunities that are presented through this. And right now in the civil division scheduling, there's X number of hours to work with. So I wanted the committee to be aware of the fact that this will absolutely and necessarily then result in non-eviction civil division cases taking a back seat and getting further here when we're working so hard to make progress on backlogs and to get cases of all sorts, heard. This will render those other cases into a back seat because this says this shall be scheduled. And there's a number of examples of that. I appreciate that, you did make the 2 modifications in terms of motions for alternative service having to be rolled upon within 3 days, motions for default judgments having to be rolled on within 5 days. It's been changed to promptly, so you don't have, but in our minds, okay, those are priority. They need to be handled ahead of time. The fact that you need to schedule any eviction case within 60 days, within 2 months, is a very expedited matter in general. You've got the answer period for 21 days to answer. So you're going to have a merits hearing within 5 weeks after that. In addition, the expedited hearing for that category of cases, whether there's a damage to dwelling unit, if there's health and safety concerns, if there's, I think, violence, that category of case, it has to be heard within 10 to 21 days. In addition, you have the rent escrow that's done after 14 days. So it's a lot of hearing options that right now don't exist that we have to schedule. There's only so many hours. So again, just to be aware, that means that everything else that would have normally been scheduled during that time is going to be pushed off. So unless there are additional resources, unless additional judges, courtroom operators, personnel, you're going to see a backslide, just because of the requirements that are now built in for these additional hearing options. And then I was going to just, and I recognize like when Cameron said, so there's a little bit of a deadline. 21 days is a very short deadline, especially if you have the other shortened time frames. And it makes mention of the jury trial being afforded. I'm sorry, but there would absolutely be no way possible that you could have a jury trial within 60 days unless you had a separate jury panel and a separate jury draw. And even then, it would be unclear whether that could even all possibly be accommodated. And I thought I'd also just mention what the current scheduling is, if that can just give some idea. I mean, now when you have an eviction case that's filed, you would have typically one merits hearing scheduled versus this variety of other potential hearing dates. Or if it's a rent escrow case, which is roughly about 50% of eviction cases typically include a rent escrow motion, which means that a hearing would be scheduled after 14 days notice. And in terms of surveying the state, every unit has a rent escrow block, if you will. And it varies depending upon the number of cases. For example, Chittenden has rent escrow days 3 Thursdays a month. So 3 times a month, you're going to have your rent escrow. When it comes in, it'll get scheduled for the next available scheduling block. And in Rutland and Bennington, it's 2 to 3 times a month. In Wyndham, Washington, Caledonia, Orleans, and Franklin, twice a month. And in the smaller counties, at least once a month. So you get your rent escrow hearing typically in short order. And many times at the rent escrow stages, when you have settlement, when you have cases either settle, I mean, it might even be here, we'll forgive your back rent if you agree to a writ of possession, for example. Or they might work out an agreement, with whatever rental arrangement it is. But roughly 50% of the cases now have a rent escrow order, rent escrow motion, and you have that kind of timeline for addressing them. Otherwise, you have the merits hearing. The disposition rate right now is 180 days, 6 months. And 80% of cases, other than the rent escrow, do meet within that 6 months. And I think testimony came out when we had the hearing on landlord tenant cases in general, that many times, if it's more than that, it's because the landlords have requested it or the lawyers have requested an extension. There are different circumstances that might, necessitate that. Actually, many times in the cases that involved a criminal action, they were waiting for the criminal case to end because they felt they had to prove it, and there was testimony to that effect as to why they might request continuances. And when I say 80% of the cases scheduled are disposed within the 6 months, a number of them are disposed within 2 months, within 3 months. It doesn't mean that they went the full 6 months. So I just wanted to paint a picture that's kind of what the situation is now for scheduling. And with these proposals, you're going to be injecting, again, these options for additional hearings that are going to, again, be just as a practical matter, to the detriment of the scheduling of other matters that are in the civil docket. And landlord tenants comprise about 20% of the civil docket. So also to just give you that information. So again, we're not saying that we disagree with any of the policy considerations at play. We're just saying this is what the ramifications will be for your own information and awareness for both the confidentiality aspect of it and then adding these other hearing and scheduling mandates.
So I know that you did put a figure on that with appropriations based on the House General. Does this change that?
Yeah, this was, and this was,
This is something that you're going to get an updated figure from JFO?
Yeah, Representative Lalonde is referring to, we requested information for a fiscal note. And so we did talk about the fact that, again, unless you are comfortable with relegating the rest of the civil docket to a backseat, if we wanted to be able to keep abreast of things, we had speculated that we would need an additional 1 to 2 judges, and in half of the state, in half of the units. Will we be able to keep up with the other docket if we gave you 2 more judges to deal with just this kind of thing? Well, anytime there's judges, you need court personnel to be able to support those judges. Well, the judges and personnel. If we gave you those resources, we wouldn't have to worry about worsening the backlog in the other parts of the docket. Right, but it wasn't 2 judges and 2 court personnel. It was 2 court personnel in the larger counties, 1 additional court personnel in the smaller counties. Again, trying to project how many additional hearings would result. I mean, we had to say this is our kind of just, best guess at that, but there would be that, and that came to about $700,000 when you added all that up in terms of, if you want to be able to try to have additional resources to make up for the fact that you were having additional stressors on the current schedule and the calendars. So I'd have to go back to see, because you'd still have, I mean, you're substituting the 1 expedited hearing for the show cause hearing, for example. So it doesn't really change that. And if you have the confidentiality, I feel like you would definitely need to have a separate courtroom, just because otherwise it would be kind of impossible to keep track of blocking the access. Similar to what, there's a juvenile day, that courtroom is just for juveniles so that people can't enter it who aren't supposed to enter it. Although I guess you were saying, what if the hearings are public? So I'd have to kind of look at that to see that. Right. Yeah. So the threatening behavior expedited hearing, I mean, how many, you said 50% of cases go into escrow. Rent escrow. Yeah. I mean, how big of an issue or how many cases can one predict would involve those scenarios? Yeah, if we're focusing on threatening behavior in that expedited hearing. Right. Yeah, we were able to run a report on the motions for rent escrow because we have a data point where if it's a motion for rent escrow hearing, for example. But there isn't like a motion for, it would be embedded in the complaint what the reason was and whether it was for health and safety reasons. So that would involve reading through each complaint, figuring out, okay, this is a complaint that would be in that category. I'd be happy to kind of canvass court staff to say who work in the landlord tenant docket, what percentage would you say anecdotally would be? That's going to be my only best way to try to gauge that. I don't honestly have a good feel for. I would have been able to, when I worked in the courts, give you an answer, but I don't know today, sitting here right now, what a good answer will be for that.
Okay.
And I'm not disagreeing that. I think it sounded like, at least from the other testimony that was given, that that's an issue. Being able to, the idea was to have those cases addressed more quickly, but it sounded like they weren't for a variety of reasons. And this would be one way for them to be addressed more quickly, certainly.
And so you are still working for a fiscal note regarding the impact, and perhaps it can also have the impact of what this change would do.
Right. Although I think he had said that Thursday is when the fiscal note was due, tomorrow. So, and I did say when I wrote, this is based on at that time the version, and that these amendments were feasible, but I can certainly try to do my best to see whether I don't know that it would be drastically modified, just because, again, not disagreeing with policy reasons for it, but just that it would result in more hearing time than right now is afforded these cases.
Okay. Any other questions for Carrie, or did you have anything else?
No, I really appreciate the opportunity to comment, and we also very much appreciate the efforts to address the issues that have been raised with previous drafts.
I appreciate it. Keep on.
And Judge Sony, I didn't know.
Yeah, Judge Zone, if you want to join us, if you wanted to weigh in as well on the latest, the amendment, I guess, as we can focus.
You're muted.
It should be okay. Can you hear me?
Yep.
All right. Look, Tom Zone, Chief Superior Judge. Nate, can I share my screen for a moment? Or Nate's not there? We'll try.
Apparently you can't, because he has disappeared.
That works then. So I will, I'll follow up on what Terry said with your discussion about the question about, are the hearings open to the public or are they not? Under section 4872, and this is in the version 4.1 on page 25, lines 6 through 9. It says, all records of a newly filed ejectment complaint shall be confidential. It then goes on to explain that they are designated as confidential upon filing and remain confidential except pursuant to section 4873. And that's that new section that's part of the amendment today for opening them. So that's the section that says all records are confidential. If you go one page earlier on page 24, it's the definitions section. If you look on lines 9 through 11, it defines ejectment record as any recorded information pertaining to an ejectment case that is in the possession, custody, or control of a court or was in the possession of a court. And then below that, it defines record to mean any recorded information made or received pursuant to law or in connection with the transaction of any official business by a court, including all evidence received by the court in a case. Testimony is evidence received by a court in a case. So the idea that Terry is putting forth that this is an open proceeding, this language does not lend itself to that type of reading. This talks about all evidence received. If a court is receiving oral testimony, it becomes part of the recorded record. And so if the intent of the legislature is that the hearing is open, there needs to be changes to the language and there needs to be clear legislative guidance for that, because this does not indicate that. Right. This indicates the opposite.
So that part, I was mistaken. Of course, Carrie's right.
The other part that I understand trying to find a path forward there. The problem that I think you run into is if you say the records are confidential, but the case is not, you have to provide guidance and I'll say a lifeline for the clerks to be able to know what they can and cannot say. If one of you, for instance, walked into the courthouse and said, is there an ejectment case with person A, B, and C today in the courtroom, can the clerk tell you, or does the clerk have to look at you and say that's confidential? The clerks would need some guidance as to what they can release and what the courts can put up. So I just wanted to point that out as a dilemma. I think that you have to take a close look at. As far as the amendment, just a few quick points. I want to make it very clear. I think I've made it clear before, hopefully, that we address everything promptly to our best efforts to address cases promptly. When the legislature puts in language of specific dates, it is our intention to meet them. I know that there are exceptions here for good cause, that things can be continued, but it is not our desire to honor your legislative enactments in the breach. It is our desire to honor the legislative enactments. If you say we want something within 60 days, we're going to deliver it within 60 days. Now, again, if there's good cause, that's fine. But we don't want the exceptions to lead, if you will. We have to try to meet what you're setting forth. And I would agree with Terry that the policy being set forth through this bill is that this takes precedence over other cases. And so when a judge is sitting there and they've got two motions they got to look at, and one fits under promptly with landlord tenant, and another is a corporation that is trying to get a writ of attachment or something. Well, you're telling us you want this dealt with sooner. In other words, there's a prioritization that this sends a message of, and that's also a scheduling from the clerks. So we are going to do our best to deliver. There is a couple of things jumped out at me after, and as Chair Lalonde, as you indicated, we had talked about this. On page 3 of the amendment, lines 6 through 10, there has been an added language that allows the parties to reach an agreement for a partial to reduce the amount to be paid into court under the payment of rent into court. The second sentence says the motion for reduction shall be accompanied by affidavit setting forth particular facts in its support. I don't know that it's necessary for counsel or anyone to prepare an affidavit and take the time and effort to do that, because the only way the court can grant it is if the parties make a motion and stipulate to it. So the affidavit and the basis for it doesn't really have any impact on the judge, because the judge can't say it's okay or no. It's either they agree to it or they don't. So that might save the parties a little time.
Yeah. All right. Thank you. That makes sense.
And the only other comment I would make is on page 5. And it just, as I was reading it today, for some reason, it jumped out on me. Lines 8 through 10. It says, if the complaint is based on a termination under 9 VSA 4467A, the complaint shall include a copy of the rent ledger. And I wondered, do landlords all keep rent ledgers? What if they don't? Are they not allowed to go forward? So those were the questions I had. I'm happy to answer any questions.
Yeah, Karen.
Yeah, thank you, Judge One. So as we were going through the amendment, I was also looking at all the notes that I had made the Friday before break when you testified. And so I feel like the amendment addresses a lot of them. However, there are some notes I made that the amendment didn't address. And so I just wanted to circle back with you to see if you're okay, or if things changed, or more clarification is needed on that, because I don't want to leave any gaps. And so I think for me, I'm back to the version 4.1, and it's specifically on page 8, and then it's also on 19, where it's using the term particular facts. And I think you had said, what are the facts needed? That it's not clear. And so I don't know, do you believe more is done or more is needed for that? Or we can work with that and just try to get your thoughts.
I'm going to choose the category of, I think we can work with that.
Okay. In both of those circumstances.
Right. It actually, it mimics 12 VSA 4853B, which is the unlawful occupant section. And so it's not something that we use a lot, but it's been used in that section. A few years ago, it was codified. And so I'm comfortable that we can make that work.
Thank you. Thank you for that. The other one that I have this is on page 27. Again, on the 4.1 version, and it's line 3. Any person with a valid court order authorizing access. I had that there were no standards for that. But again, is that like seeing that our goal is like we're trying to create a new system, like we're not going to get everything perfect. Is this another one of those examples where it's like, okay, we can work with this?
That one's a little different. The reality is it's going to have to play out. If someone comes to the court and says, I want access to this ejectment record, the answer is going to be no. For instance, there's no provision. If there's no provision that allows you access, it's there. Now, what that could, a valid court order authorizing access, it could be an order from a federal court saying that as part of a federal criminal investigation, they want a copy. So there are categories where I could foresee a valid court order, but or other areas in the state of Vermont where a judge might find something there is appropriate. And on the balance of the factors the court and the facts the court has to look at, the court decides that, yes, the judge is going to order access to something, but there's no categories. So we're going to have it play out to see what really are the ways that people can have access to it under valid court orders, because there's no specific categories of what that looks like.
Okay, great. And then my last one is, I think it's already been addressed by Terry as well, is on page 25 with this piece of unless the court orders continued confidentiality. You said there's no standards for that. So it sounds like confidential is the thing that we're going to have to figure out and have more discussion about. But that you would agree that there aren't any standards for that, and that if we're going to keep that, we're going to need to be clear.
That's correct. It would be helpful if you were clear. Are you looking at the standards from the public access to court records rules for when we seal something or when something might be unsealed? Some guidance there would be helpful because right now we have no guidance to know what are the factors that we look at.
Great. Thank you for that. I appreciate it.
Would we, if this is a little complicated on trying to get this right, the confidentiality component, can we direct the court to consider, with the public access to court records committee, the advisory committee for that they would be able to look at how this could be workable?
That's a very, very policy-driven way to go forward. So the short answer is, could the public access look at it and talk about how to deal with it? Yes. I would then go to the should, because this is a very policy-driven question. Transparency is what they really focus on, and looking at that. This is public policy, a lot of this. Why? And so.
Sure. I guess it could be, we want these records to be as confidential as logistically possible, or we want these records to be confidential, period. But it's really, there's a lot to that and how it could actually be implemented. And it would probably be this advisory committee that would have the skills and knowledge to do that.
I would suspect that there may be very different views on the appropriateness of confidentiality and who should have access to them for what reasons, such that it's probably better left to the legislature to tell us what your policy is and your intent as to what takes precedence. If previously there was some categories that were added here that people could get access to here. Is it the intent that if someone's doing a data analysis for a law school, that they should get access to it? Is it for an organization that represents landlord or tenant rights, if they want access to it to be able to prepare things to better represent their clients?
So yeah, those would be, yes, the policy decisions on that. And I'm just saying the actual logistics for accomplishing whatever the policy is, rather than us saying, yeah, do this. We could say, yeah, do this in 2 years or year and a half or whatever would be appropriate for those logistics to be worked out by the public access court, right? It's kind of like what we're doing for access to the criminal records. I mean, that's a reverse. That's allowing more access. Here we're talking about less access. It's just something to maybe think about. But I understand that, yeah, the policy decisions are. All right. Any other questions for Judson, or did you want to weigh in, Terry?
Oh, I had a question for you though, before we leave, if that's okay. But I didn't want to, if somebody else had questions for Judge Sullivan.
Anybody else from Judson? No.
In terms of the fiscal note and trying to project the number of cases that might be involved, it appears to me that the amended version for the threatening behavior provision is broader than the current provision that talks about termination based on criminal activity, illegal drug activity, or acts of violence, any of which threaten the health or safety of other residents.
Right, that is true. Yeah.
Because it's talking about certainly damage to dwelling unit. I think that's potentially a very large addition. And then activity that threatens health or safety of is broader than what's in the current. So I feel like I'd be hard pressed to try to imagine what numbers, how many additional cases might, but I'm going to guess it could be quite a few. So I apologize.
That's completely fine. And just to get me to kind of understand where we're looking, I want to, it's not in the amendment.
No, but
We would be looking at
4467 B2 is the present one that talks about criminal activity, et cetera.
Yeah, and that's on page 8 of the draft number 4.1.
Oh, okay, I just had copied the statute itself. And then page 6 on the new, I'm sorry, it's on page 6 actually. On page 6 of the new version. Oh, sorry, you know what? 4046.7 B2 is referenced, but then I looked back at the actual statute just to see.
Right.
Actually, let me see what page that was on. The revised 4047 B2.
Right. Right, and that's that revised version is on page 8, and you're right.
Oh, okay.
Something else to be looking at. No, that's.
And again, not stating a disagreement with the policy reasons behind the amendment, but it would, I think, increase the number potential.
I can touch on that very quickly, and that is, I think that trying to look at historical data, even though we don't keep that data point, I've asked judges about how many of these cases do we have where it's selling drugs, things like that for illegal conduct, and trying to have evictions based upon that. I think the difficulty that you run into is that even though you had some cases that are brought like that, the absence of a statute that provides an expedited process may have contributed to some cases where someone otherwise would have wanted to go forward with it, not going forward. In other words, a plaintiff, a landlord may have decided, I don't want to go through that because I've got to prove it. It's going to take a while. I'm just going to do something different. And if we accept the testimony that we hear that there are issues with this, and the legislature crafts a statute that has a specific protocol, procedures, and an expedited procedure, I think that naturally we will expect to see more of those claims filed because we're providing a very clear avenue to have an expedited process.
Right. Okay. Oh yeah, Tom, sorry.
Yeah, no, this is more for you than anything. Craft's over, it's Friday. We have enough time to fix everything we're talking about before then.
That is such a good question.
Wow,
Yeah, so we need to hear
this
from.
is sounding more and more complicated all the time, and
Right.
talking about study committees, put a different term to it, but and that type of thing. And not that overall it's a bad bill, but are we going to have to rush through what we need to fix to get this to the floor by Friday?
So
I would hope not.
the only thing is that this one, it wouldn't be going to the floor by Friday. We would actually possibly have more time next week because it's in appropriations.
Oh,
And
okay.
this is a floor amendment.
All right.
That is not to say I disagree with what you're saying at all, because it does seem to be a lot, and some pretty significant issues still.
I mean,
So
it'd be a shame, but if that's what needs to be done to do it right, to bring it back next biennium.
right. So we have just a little bit more leeway on this one. So I want to at least get,
Give it a shot.
with the other witnesses to get a sense of where we are with this. Right?
Okay.
So that's kind of, yeah, I'm with you on that as well. It's got a ways to go in a very short time.
Yeah.
I was going to say a long walk and a short pier, but that would have been wrong at this point. So thank you very much.
Thank you.
And we'll go to Jean Murray as well.
I'm dreadfully afraid to not have my computer plugged in
Yep.
because it's old. And I don't know how the battery works. I don't need to be on the screen or anything.
Thank you for being here, Jean. Appreciate some time to fit you in whenever it was that you took this up last week. Was that before break?
Yeah,
It's like a long time.
Right before break.
So appreciate you being able to come back.
Hello, I'm Jean Murray. I'm an attorney at Vermont Legal Aid for 28 years in Vermont. I've been practicing landlord tenant law. 7 years before that in Massachusetts. So I've been doing this for about 35 years, landlord tenant law in 2 different states, mostly in Vermont. And what I'd like to try to do is convince this committee that this committee needs to take more time to look at the aspects of this bill that pertain to due process, court procedure, and catch up with my notes, and the court capacity, which you've heard from Terry, that the court, this bill, because eviction cases are 20% of the civil docket, the court processes proposed in this bill would shift how the courts deal with things. And so trying to figure that out, I think, takes more time. I guess one of the things that I want to talk about is there's a lot of detail and intent in this bill that is not really very well worked out. And it's going to take time from people who understand how court process works. I'm a practitioner. Last week when I was in the week before last, when I was in the committee, that week I filed 2 motions in court to try to prevent families from being evicted because of behavioral things that had to do with their disabilities. And so the devil's in the details, and there's a lot of problems with how this thing could work. And at the same time, one of the things I wanted to say is when we had pandemic money, meaning Vermont Legal Aid and a lot of the community action programs had pandemic money, we were able to offer more services and do what we could to promote housing stability. We don't have that money anymore. And fewer tenants are going to be represented by counsel. And so when we had pandemic money, only 12% of tenants got lawyers. And now we've lost funding. So to the extent that any of these court processes depends on defendants themselves being able to advance their case, it's really not, as a practical matter, going to happen. So the objective of this whole bill is to reduce expenses for landlords by saying there is somebody, if somebody's not paying the rent, let's get them out fast. If somebody has violated something, let's get them out fast. If somebody is causing harm to others, let's get them out fast and not have a prolonged, expensive court process, or have a more predictable one. But the problem with it is tenants are 30% of Vermont's household. That's 80,000 people in Vermont, and these processes will all apply to all of them. There are programs in Vermont to help tenants catch up and pay the rent. There's a lot of things about this bill that would just take that process away, including this idea of being able to pay and stay, to pay up all your rent and keep your tenancy. Right now, the current law for that is that a tenant can pay all their rent due, the court costs and the sheriff costs. If they do that up to the time of the execution of a writ, they can go to court and say, I paid, actually they pay into the court, and say, this eviction has to be dismissed. It's a policy favoring payment of rent, and it's a policy allowing tenants to keep their housing. But in order for tenants to do that frequently, they have to access the other programs that this legislature funds and supports. And when you shorten the timeframes, they can't do that. So it's going to result in a lot more evictions. It's going to take up judicial resources. You may hear that other states have shorter eviction timeframes. Other states have different circumstances when it comes to their housing courts. They have housing courts themselves. They have mediation programs. They have eviction diversion programs. They have different vacancy rates, and some states have required certificates of occupancy. So we're not talking about as big a problem as Vermont has about habitability, which is a reason for withholding rent. They have well-funded rent assistance programs. We have rent assistance programs, but they typically run out of money before the beginning of the fiscal year. And we're now really battling about whether or not Vermont is going to have sufficient programs to shelter the homeless. So there's a lot of reasons to think if you're going to do something about eviction process, you need to take the time to do it right. So in my written testimony, I said there is an intent in H772 to defeat the civil rule requirement that civil process be just as well as speedy and inexpensive. Talked about, let me advance my notes. So the rules of civil procedure, and I brought mine because I have to look at them all the time, every day, and the landlord lawyers do too. They're for civil process, the rules favor decision of cases on the merits at a hearing where the party who's asking for relief produces evidence. Throughout case law, throughout the civil rules, throughout statutes, that's how civil process is supposed to work. On the merits, at a hearing, after evidence. Another thing that civil rules favor is requiring all claims arising out of the same transaction or occurrence to be brought in the same case. Another thing is the civil rules favor amendment of the pleadings if something got left out the first time or something new happens while the case is pending. Allow the person to bring that into the case. Allow parties to conduct discovery. And after a just adjudication or a fairly produced agreement, the rules favor finality, so you don't have to keep coming back and back. I don't know of any rules that deny process to one party while making that same process available to another party. And there are many aspects of H772 that do that truncate that. So for example, even in the amendment, which I didn't have a whole lot of time to look at and analyze, but the amendment to get an expedited hearing comes in and says, you need to do this on it. You have to have an affidavit accompanying your request for expedited hearing. But if the defendant wants to oppose it, the amendment now says that has to oppose it pursuant to Civil Rule 7B6. That rule says your opposition has to make a case that live evidence in court is needed. So the plaintiff doesn't have to make a case that live evidence in court is needed, but the defendant has to make a case that live evidence in court is needed. So in that way, this is an uneven bill. Now, we have a process right now, rent into court process, that also requires defendants to make that case. And if we had time to say you should repeal rent into court process, I would make that case, but that's not what we're doing here today, because that's a very unfair process. It only allows landlords to make that motion. It requires tenants to meet a much higher burden, and doesn't allow them to change things. Well, H772 says tenants can't now try to change or rent in the court order. The amendment takes out the suggestion of small claims court appeal, because small claims court does not have any kind of jurisdiction to order anybody to do anything. But I guess that leaves in there landlord possibility to tell tenants who their guests can be and who they can't be with no appeal. Which, for me, really says the flavor of this. Landlord is such an awkward word, right? We don't talk about people as lords anymore. But landlords now want to be able to dictate exactly what a tenant does and how they behave and who they can have over and things like that. And so, and that makes tenants somehow second-class citizens. I don't know. Okay, well, I want to talk about standards for emergency hearing. It's not as if the law never had a standard for emergency hearing. There's certain statutes that have standards for emergency hearings, but generally in the rules of civil procedure, the standards for emergency hearing are actually sort of ancient. But so in current law, a person who is aggrieved of something that someone is doing that is likely to cause irreparable harm, under Rule 65, they can come to court with an affidavit based on personal knowledge. And that affidavit has to make out a case that as time goes forward, there will be irreparable harm. And in which case, the judge can give them an order to serve on the other party saying, stop that. Right? That's an ex parte temporary restraining order. The temporary restraining orders that we now embody in relief from abuse orders are based on that process. You can come in, make out a case that something bad is going to happen unless the court acts. The court reviews that and says, yes, you've made that case. I'm going to give you a temporary order. And then in case of civil process, you can come back to court within 28 days and have a hearing to show that temporary order that you asked for should be made permanent, because you can prove that there will be irreparable harm. This says, nope, there is no court review, even in the amendment. H772 says, if you file a case alleging one of the grounds in the reason for termination, 9 VSA 4467B2, if you allege one of those reasons, and the court just has to give you time in court 10 days later, you miss the step of court review. Did you make out the case that you need emergency review? And why that's concerning to me is because when I look at 4467B2, what is in there now and what is proposed to be in there under H772, it says when the termination is based on acts of violence, damage to the dwelling unit or premises, or other activity, any of which threaten the health or safety of other residents. And when I saw or other activity, I mean, I had a case where the tenants were at each other's throats because of parking when there was snow that had been pushed. Look, the one person couldn't get out of her apartment and she needed her car right next to her apartment. So it did threaten her health and safety because she was trapped in her apartment by the way the other person parked. So these are very broad terms, and I don't think anybody thought if that is all you have to do is write down something that fits one of those definitions. You require the person to, they only get 5 days notice. Now the amendment now says they can have 21 days to answer and a hearing in 10 days, and you can get somebody out without court review about whether or not irreparable harm will result in the future if that behavior continues. And so a lot of people we represent, a lot of folks who have a hard time with behavior because they live close to their neighbors, those people have disabilities. So, for example, this would cover somebody who is being evicted because they have fallen on mental health bad times, and perhaps they have begun to hoard more things in their apartment just because they're not taking out their trash. And so that person, so we had a case where that was the allegation, and with help, we were able to get a social worker, get a cleaner, get the change to the physical premises, because it does say damage to premises. We got to change the physical premises and got that person support and retain the tenancy. But in that sort of short time frame, you would not be able to do that. And so I agree with Judge Sonet and Terry Porsones that right now you don't see very many of these kind of cases, but you would see a lot more cases because somebody says, I don't like the way you have behaved. And I wanted to point out that's another problem with it, which is the thing that gets you into court, the termination notice under 4467B2, talks about something that has happened. It doesn't talk about something that will happen. And so it's not very narrowly drawn. You could get somebody out in very short order for something they did without giving much of a chance to inquire or get help on whether or not that will still keep happening. And for pause evictions, that's really the essence of what this is. I have a case right now where there's one incident which would fit this statute, one incident, one day. And whether or not that was going to keep happening is not a part of it at all. So what else did I want to say about this?
So I will note on the amendment on page 6, line 18, is that the defendant is threatening the health and safety. So it is based on 4467B2, but it is looking forward that the threat is currently happening. So it's not just tied to 47B2.
One of the things I notice is that's the proposed 4863 or 5, or I can't remember which one it is. But anyway, it says you can file on 4467B2, and then it says is threatening. So to me, that's unclear. If you can get in on anything that's in 4467B2, which it seems like that's what it says, it doesn't say only if is threatening. It says it's so that is threatening, or B2 actually says, or the page 772 version of B2 says, which threaten or threatens. And then the Title 12 piece says it is threatening. I'm taking the word for it. I don't have it in front of me.
Yeah.
Yeah.
It does
So,
have a forward-looking aspect of it as well.
but I guess the point is, it's not about whether or not you want to accomplish a goal of having a procedure for people that are threatening or continue or predictably going to continue to cause something like irreparable harm. It's not whether or not you could have a procedure for that. I'm saying this, and even with the amendment, doesn't do it, and it's not crafted to do that. And so that all those kind of things are going to take more time to figure out how to do it without having too wide a net and bringing in people that you that need more help than being evicted.
I just have to do a time check, so we only have
Okay.
4 minutes, and we have a couple additional witnesses. That we-
There was a lot of talk about the confidentiality piece and the public access to records. I've done some motions on those. There's a ability for, in public access to records, there's a exception where people can ask for certain things to be sealed after the fact. And we can, even in cases of domestic violence, we haven't been able to be successful in getting things sealed because there's such a policy towards public access to court records. And so again, I agree that this legislature could make a policy decision about sealing records. And the whole point of sealing records is to take down a barrier to people who have lost housing and are now trying to get housing, to having an eviction record. One of the things about eviction records is once your name is in the docket and discoverable in the docket, it doesn't matter whether you won, lost, settled, paid up. It's in the docket and you have been subject to eviction, and therefore somebody can say, I'm not going to give you housing because you were subject to eviction. So the idea there to have confidentiality or expungement or sealing would be to remove a barrier for people who have been evicted in the past or had an eviction brought against them and now are trying to get other housing.
So on that, I mean, if we, since I've heard a lot of problems with the approach that we have here right now, is it sufficient that if at the end of the case is dismissed, the case is not, found against the landlord, that time the document could be sealed, and including that you can't see it on the docket. I'd have to double check to make sure I understand that, but I think if they would say the record doesn't exist, is that going to help if we do something like that? That's doable. That's, I think, because we're doing that right now with a lot of criminal records.
Yeah. Yes. I think that was the objective in the first place. And, legal aid advocated for a sealing or expungement bill and ended up with this confidentiality place to it.
Right.
But again, it's something that could be worked on so that the goal is accomplished of not having a permanent record of eviction that would be a barrier in the future for anybody trying to find an apartment.
Well, I think that is eminently doable. Yeah, okay.
I guess I said this already, but I just have to emphasize it. The idea that somebody can be evicted in a short period of time where there are blocks for the defendant to hear live testimony in court and have the court decide if the testimony and evidence meets a standard. To me, that is mind-blowing, that even the motion process suggested, it allows an order to be made without live testimony. Right now, if you go to court and the other side doesn't show up, the best way, if you're a plaintiff and you want to win your case, is you go ahead and put in the testimony, even though the other side isn't there. Then the court has heard the testimony, says it meets the standards, and gives you a judgment. this idea of you don't show up and it goes to a default, that's really not a good idea at all.
Chair, may I ask a question?
Yeah, go ahead.
I'm hearing that and I'm trying to understand, are there examples of it where it does exist?
What?
Where that happened, I'm seeing it, yeah. That you would go to court and you don't show up and there is a judgment that's just made. So I hear that maybe it's not ideal, but it sounds like it's not a new idea.
The reason the judgment is made if you don't show up at court is because the plaintiff puts in their evidence and there's no contest to the evidence and the judge doesn't have anything to detract. You know, the plaintiff becomes more credible if the defendant doesn't show up, but the judge hears that it meets the standard and makes a decision. For example, if let's say you weren't actually the owner, the plaintiff wasn't the owner, and the defendant didn't show up, shouldn't the judge ask, okay, please explain to me that, testify in court that you're the owner, and that you have a right to evict this person, right? That at least should be something that the court should hear, as opposed to, they should have some evidence that the person's the owner and that they have the right to evict them, that they sent a termination notice. They should hear that.
I hear, and I guess I'm just trying to put it in a piece of that. It's not a brand new idea that's being put out there that judges can make orders without all parties being present.
Sure, judges can make orders without all parties being present, but you don't call that a default. You call that a judgment. As a matter of fact, that would be, maybe I don't want to say this, maybe that's better for the plaintiff, because if it's a default, then somebody can make a motion to remove the default and start over again and try to have a hearing on it. If it's a judgment after evidence that you didn't show up for, then
so it's terminology.
Yeah. So I do think that there's a lot of due process, civil procedure, court scheduling ideas that need to be worked out better if any of the aims of this bill should go forward. And I understand the policy parts aren't the jurisdiction of this committee, but there's a lot of policy parts that are really very, very slanted towards landlords and against tenants.
Appreciate that. I appreciate your testimony. We do have to move on to a couple more witnesses.
Thank you.
And thank you very much, Jean. We'll go to Angela, who I believe is appearing by Zoom. And if you could identify yourself and proceed with your testimony.
Sure, certainly. Thank you very much for the opportunity today. My name is Angela Zakowski. I am the director of the Vermont Landlords Association. We're a statewide trade organization here in Vermont. And also, I am a practicing attorney. I have a private law firm where I represent housing providers around Vermont in pretty much every civil court in the state with eviction actions and other housing related matters. So I also come at it from a practitioner standpoint, understand these rules, how they work in practice, and sort of the impacts that they have sort of on both sides. So not only housing providers, but also every single other tenant in the building that has to live next to somebody that's causing problems in that building. And that's been sort of the ask and the impetus for a lot of these changes that are included in 772, is that there is an issue with the amount of time that it takes to have somebody removed when they're causing a problem in a building. And it's time that impacts the landlord, but it's also time that impacts other residents in that building. So landlords spend a lot of time dealing with complaints and concerns of other residents while these processes work their way through the system. So while many times non-payment of rent cases will move through the court system relatively fast, 6 months or less. That's not really fast if you're a landlord and the tenant's not paying the rent, but in terms of court process, that can be relatively quick. But if you have a tenant that's damaging building, having violent acts against other residents, dealing drugs out of the unit, threatening residents, threatening neighbors, threatening the landlord or property manager, and you start a case for those violations, those tend to be some of the longest cases to work their way through the system. It is not uncommon right now for a case related to behavior to take 9 months, 12 months, and I actually had one that took 2 years. So it's an incredibly long process for these types of violation issues for not only the landlord, for the tenant that's under eviction, but also for everybody else in that building. So part of this proposal is the ask to help speed up that process to create less impact in the building, less impact for other residents, and to find a way to address these issues in a more expedited fashion. So I think looking specifically at the court process language that was presented for today, this does provide process. This provides a level of due process that we currently see with the rent escrow process, that we see with unlawful occupant process, and it requires the landlord or the plaintiff in the case to ask for this faster process by motion. So it's not required. It doesn't mean it's going to happen in every single case, but it is permissive. So if a landlord chooses to use this expedited process, they can. And in order to do that, they have to file a motion with the court, and they have to file an affidavit with the court that lays out their legal basis for their ask, not dissimilar to what we see in rent escrow currently, not dissimilar to what we see in unlawful occupant currently. And then that request gets served on the tenant. So now they've been provided with notice for a second time, because remember, they've already gotten a termination notice from the landlord before they can even get into court. So they've already had some initial notice that there's a problem. Now we're in court, we get served with court papers that says, here's this process again. And oh, by the way, here's a court hearing that is going to happen on this issue. So again, due process, right? We have a court hearing that gets scheduled. That's the 10 days notice, but no later than 21 days after the motion is filed, sort of section of this bill. And at this point, the tenant has some options. They can show up for the hearing where the court will take evidence, or the parties will work out some sort of agreement, or there'll be a court hearing of some sort. They can file a response as outlined here, or they can do nothing. Those are all options that are available to them now for the unlawful occupant process and for the rent escrow process. But all of these roads lead to a court hearing where a court will potentially be taking evidence if both parties are there. If the defendant doesn't show up, then generally the plaintiff wins by what we call default in the legal world, which just means that the defendant has failed to appear. Some courts even now require some level of testimony to support, or just an affirmation of what's in the affidavit that was previously supplied. But this sense that there is no due process or no opportunity for court review does not track with what the language in this bill is. So there's opportunities for tenants to state their case and to come in to convince a court that the behavior that is being described does not threaten the health or safety of other residents. Really, that's what we're talking about, right? Sort of egregious behavior that's threatening the health or safety of other residents, the landlord or the landlord's agent, and neighbors. They're creating a safety risk in a building. And yes, some of the language does have a catch-all, because there's a lot of situations where the behavior could threaten the health or safety of other residents. And so, this piece, while it is happening much more quickly than a normal eviction case, sort of tracks with that unlawful occupant case. It tracks with the rent escrow process. And it is intended to deal with those very extreme behavior cases that we're seeing. And I think from a policy standpoint, it seems very unfair to tell those other residents, well, you've got to live longer next to this person that's causing these problems in your building, or you have to be subjected to that tenant that is threatening you with, I'm going to blow up your car, or I'm going to stab you the next time I see you, or sometimes that actually does happen. And so what we're asking for is a faster process to deal with those issues through these changes. And I have to commend the committee because I think the changes that were made from 4.1 to 2.1, I think this addresses a lot of the process problems that were raised. And I think it clarifies a lot of the issues that the court had. And from a practitioner standpoint, I read through this now and I'm like, okay, I understand what we're doing here. This looks familiar to these other processes that we already have in existence. And, will there be some growing pains if this goes into effect? There always is, right? There's always, the judiciary's got to figure out how we're ruling on cases. Practitioners have to figure out how we're presenting cases. And we managed to do that. But I think the framework is here. And it is in a format that we're used to seeing.
So did you have more or did you open for questions?
I have more, but I'm always happy to take questions
go
if
ahead.
they're on top of mind, because I know how quickly they come in and out.
No, go ahead.
Okay. I wanted to make a quick comment about the trespass order piece that's in here. This is a pretty significant problem that housing providers are running into. And this language has attempted to be tailored to deal with those situations where a housing provider has gone through a court eviction process. They have gotten a writ of possession from the court to have a person removed from their unit. And then that person is coming back onto the property and is continuing to cause problems at the property. This is what I refer to generally as the Decker Towers problem. So Decker Towers is a relatively well-known building in Burlington. You can Google Decker Towers and there's a number of news articles that will come up about it. What was happening was the owner of that building was evicting tenants for dealing drugs. Though that household would get evicted out of the building and then move into another unit in the building and continue to do the same exact thing, deal drugs out of the unit. And because of the way our laws are currently written, the landlord would then have to evict that next household. And then that eviction would go through and those folks would move into another unit in the building. And so they were having to work their way through the building with evictions instead of just being able to exclude the first set of tenants who had already been legally evicted out of the building. So that's the ask for this particular change as it's related to no trespass orders. And then finally, the piece related to confidentiality. This is a very hard one for me as a practitioner and as somebody who believes that we should have open records for our court system. And I understand that there's certain dockets that have been deemed to be confidential that the public doesn't have access to, but an open judiciary and open records to what's happening in court is, I think, one of the fundamental basis of our democracy in this country. One of the tenets that we sort of hold dear. And I think taking an entire group of cases and making them confidential from the outset has runs the risk of creating more problems than we're intending. What I don't necessarily have a problem with is there a set of standards that we could create that would allow somebody to ask to have their case sealed? Right? Are there certain categories where it would make sense for there to not be access to a specific case instead of a blanket coverage of an entire grouping of cases? And I think for a lot of the reasons that the judiciary laid out about the challenges with confidentiality, I would sort of express support for some of those concerns as well. Just taking a look through my couple of different versions of the bill here. All right, I think I'm set with my direct form of testimony, but I am happy to answer questions. I'm sure there may be questions.
Questions, anybody? Actually, I don't think at this point, we're all kind of thinking.
Yeah. There's a lot.
What to do about this. So no, thank you very much, Angela. Yes. I didn't have it in front of me. Sure. Thank you very much. So we'll have Chris join us now.
Good afternoon. My name is Chris Donnelly. I'm with the Champlain Housing Trust. We represent the 3 northwest counties of the state. We steward roughly 3,000 apartments in our portfolio. So we're a pretty large landlord, maybe the largest property manager in the state. But I'm also here representing a wider network around the state of organizations like ours that cover every corner that oversee 8,300 apartments. So it's pretty wide range of organizations. And this is one of our this bill is one of our number 1 priorities for this.
Are you representing Cornerstone?
Yes. Yep. So if I could go through the organizations.
No,
there's each.
I'm selfish. I'm happy with that one.
Our organizations collectively, we operate by some different rules. We won't move you out if you're paying your rent on time and your lease comes up. We just automatically renew your lease. So we operate under kind of what people think of as just cause protection, just cause policies. We have rent stabilization, so we don't raise the rents 10% every year or whatever. We're regulated that way. Our organizations as regional nonprofits also are the organizations that the state looks to when there's a crisis, whether it's pandemic, flooding, financial crisis, moving people out of homelessness. We have been really laser focused on trying to get people out of the motels, so we're not spending money on the motels as much, and moving them into permanent housing. Whenever anybody runs into problems in any of our apartments, we respond with offers of assistance. We have social workers on staff. All of our organizations have resident services, people that engage with our residents. So our first step is to offer help, connection to other programs, whether it's back rent, what have you. We try to cure any problem right there. I will say, though, that the situation right now with both back rent that's owed to us and then challenging, threatening and challenging behavior in our properties is destabilizing our whole network in several different ways. I can talk more specifically about what's happening in our shop. Before the pandemic, we had roughly $250,000 in back rent owed to us, kind of ongoing. That's just what we would be working with each year. It got brought down to close to 0 during the pandemic because of all the programs, which is just awesome. It was great stabilization for our tenants. It's gone back up to 600,000. And so it's destabilizing for our financial capacity. That's happening in smaller versions around the state. We have increased our spending in security. We actually have hired a director of security net. And we have spent about $750,000 a year just to install cameras and do stuff just to make sure our properties are secure. So that's money that we're not spending on other things. We've hired up to 20 resident service people that can now engage with our tenants, and that's more than we used to. So these are resources that we're trying to bring to bear to kind of address the stability of people's housing and protect the rest of the tenants in our building. Angela talked a lot about the impact of some of the activity in apartment buildings on other tenants. That's really what keeps us up at night. So this is really destabilizing, not just financially, but we have reputational risk from this in our communities, and we want to build new housing. We also are losing staff over some of the situations in our properties. In our shop, we have a list of 60 apartments that are kind of have a red flag on them, saying if we need to go in to make a repair or so forth, we should think twice about it. We have 12 that we won't go into in our shop. So it's a small number, but it's really significantly impacting our ability to address concerns, and that has a much broader impact on our residents. So we've been asked to do more in the last several years. We've been asked to house more people moving out of homelessness. Right now, collectively in our portfolios, roughly a quarter of the people that we house had moved out of homelessness. That's a lot of extra work that we're doing to try to solve these issues. And those people are vulnerable. Those people need as much support as anybody. And so that's really what this bill for us does, is it really kind of protects those other tenants. We feel like waiting longer, it's just going to put more people at risk. And so we really encourage you to act. I do think there are other ways the courts can establish priority. I think this should be a priority. I think this is it's threatening the health and safety of folks. So I'm not a lawyer. I'm not going to go through the bill and talk about the court process. And yes, heard a lot of that, but I'm happy to answer questions.
Thanks for being here. So I'm wondering if you can talk about how much you've been able to use. We heard from Terry, like what the dates are and how frequent people can come in.
Yeah.
So what's it like now when you try to go through an eviction process?
I was here yesterday, and when I went back to my office, I checked in with the property management folks because we got a new draft of the thing, and they had done 2 evictions yesterday. One was 7 months, one was 11 months. And both dealing with drugs.
And what was can you talk about why it took that long?
Yeah. Typically it can go faster, and Angela did this with down payment. It's just easier to prove you didn't pay. Some of these other types of activities, it's just harder to prove. We had one tenant that set fire to the building. That certainly threatened the health and safety of folks, and that took 11 months.
Why?
So several reasons. So in that one, the sheriff showed up several times to serve, and they wouldn't answer the door. And so we go and get a TAC order and do that. And it's assembling the evidence. It's going through the process.
So once you file the evidence, how long is the court taking?
It ranges, but I don't have a specific date. I mean, we have a list of all the evictions. I could probably compile that for you.
I guess I'm just trying to figure out where the hangups, like, is compiling I don't know what's involved in compiling the evidence. If that's something you rely on the people to get you documents.
Well, we have put camera footage. We have a very hard time getting neighbors, tenants to go on the record and state that their neighbor is causing this havoc. So that's a challenge. So we don't have that type of direct experience. So it's a range of things.
I'm also wondering, for the apartments that you've talked about that you won't go into repair, are you actively doing like evictions on those right now? How much does it cost you to have an eviction and to have an apartment turnover
We spend about $300,000 to $400,000 in legal fees
per
a
eviction?
year.
Okay.
And,
That's-
and that turnover is depending on what's happening. And that could be $15,000 to $20,000.
And is like, have you been able to like do anything different with screening? Like, what, are there other steps that kind of, or services, like if like Shelter Plus?
Yeah, now we access every single program and service that are up there. It's a lot of it is really about the drug dealing and the violence. It's, if it's a mental health thing, we'll just figure out a better place for people. And sometimes that means, convincing people that they need to go to the hospital, or find some other location to live, instead of evicting, that they can access better services.
And I know Champlain Housing Trust is like very committed to housing people. And I guess I'm wondering what your thoughts are hearing legal aid's testimony and like what it might do to this system.
My sense, and others may have a different opinion in this, but my sense is moving evictions faster. Just move evictions faster. It wouldn't necessarily cause more evictions to happen. It just will move people through the process faster. If a landlord is collecting rent and everything's fine, there's no reason. It's just when there are issues, and those issues can be costly, but they're very disruptive, and that's what keeps us up at night. Is the disruptive behavior, and we deal with the economic issues of it much easier than and that's why in this bill there was $1 million for a background program, and we really think that these things need to go hand in hand. Questions for Chris? Okay.
So, you're on a nonprofit side with this here, and you go and all these apartments that you handle and stuff like this. What happens if it gets so out of control that there's no money to, a regular landlord has to pay their bills and stuff like that. What happens when your entity can't do that?
So I will say there are a few buildings in Burlington that we have boarded up and just said, we need to just stop this right now. And just like, it's costing so much money that we need to move everybody out, different place, get people away, and we're just going to board it up, and we're going to wait for another use. And then we need to go borrow money and reinvest in that property. It hasn't happened to us because it's fine, but I have heard of stories in the Pacific Northwest, that there are some nonprofits that are selling their properties because there's so much debt, so much rent arrears or debt. And
But you don't have any in Vermont that's happening.
No.
And you probably can't talk about the others that have just had enough and just boarded up there or locked it.
Yeah, I know that there's another organization, and there's a letter on your page that is converting a building that was used for 100% people moving out of homelessness, permanent supportive housing. They're converting it to just more generic kind of affordable housing. I'm not saying that we need to move away from that because of outside influence that's come in. So read that letter. It tells a story about what the things we are thinking about we need to do.
Yeah, I mean, we built or taxpayers certainly helped build a new complex right around here, and immediately it became a problem. It continues to be a problem. We have the drugs in there, we have everything. Brand new apartments that I think was actually, we put in use, I think, last June, something like that. It continues to be a problem. And then, again, I don't know of a landlord out there that wants to get rid of a good tenant. Usually there's a reason. To get rid of them. And the other big thing is once that landlord can finally get into that apartment, if there's any type of hoarding or if there's any type of, God knows how much garbage they leave behind and it runs down into the ceiling and everything has to be replaced and everything like that. You have no way of knowing what it's going to cost. How do you guys handle that situation?
So these are, what you're describing is, it's rare. It's like one bad apple in the bunch, right? One bad apple in the barrel. It's just it's causes other issues, right?
I don't know how big your barrel is. I know there's smaller barrels and you try to get good tenants and you go over everything, but.
What as most property owners have is you have cash reserves for both operating and you have for capital reserves. So you need to just start using your reserves and then you need to build them back up. If it's really substantial, then you may need to use a program like VHIP, the Vermont Housing Improvement Program. So you figure out that when you get there.
Been there, done it. It's not fun. Thanks.
Thank you, Chris.
Oh, can I ask?
All right, yeah, last question, make it quick. Sorry. If the answer, I'll make the answer quick. Too slow. Three words answer.
Pretend I didn't hear that. So, you strike me as someone who is in a somewhat unique position, or I would say for me, a helpful position, because you are both, your organization, the people you work with are both, you're helping, in many ways, helping some of the most vulnerable Vermonters who stand to, benefit from protections for tenants. And you serve the most vulnerable who are at risk to be the most negatively impacted by some of the policy choices in this bill. So I'm looking to you as someone who sits at that nexus to help me understand how I should think about this bill. Can you just offer some thoughts on the balance that?
Yeah, I mean, this bill has been, as it's moved through the process, has been an attempt for this balancing act. So for example, some of the sections that you're not talking about, it extends the notice period for people at the end of a lease. So right now, in the current law, it's 30 or 60 days, depending on the situation. So when the lease is up, it extends that to 90 days if the property owner doesn't want to renew it. And then it offers an opportunity, because we know what the market's like, to get some of your deposit back early. So you can use that for your next rent or security deposit. So it offers some balance in here. I think for us, I just can talk about for us, we don't move people along unless there's a real reason. We only move people along for cause. And then it's non-payment is a simpler thing than some of these other things. And that's really, like I said this before, that's what keeps us up at night. It's just a threat on our other tenants.
Great, thank you. So this is a bill that, as we have a little more time, because we can, because appropriations isn't voting out until next week, and this would be a, Michelle. This would be a motion, this will be a floor amendment, so we have some more time, so by way of telling you, Brenda, that we're gonna have to bring you in next week, if this bill is gonna continue to be moving. And we have some things to think about, confidentiality, moving to ceiling. There's going to be some more offline communications, I think, with between chairs of this committee and other committees looking at this, so to see if the way forward. So, yeah.
I just have a procedural question.
Yeah.
Are we going to be taking more testimony on this?
But it depends. We're definitely going to hear from Brenda because I told her that we'd hear from her. If we have more changes, if we're going to have some more changes, then we'll have people weigh in on changes. I mean, I think we've heard from the different sides that we need, but if there are
Seems that
particular
way.
people that you need, that you think we need to talk to.
I feel like we've.
Yeah, if we're gonna make
we've heard all
some-
we need to hear.
Yeah, well, but I did say I had one more person to testify and
Should
we'll
we
have
give-
that person, but no, I do want to get to this next bill to have a walkthrough of these so people can think of it, consider it, H171 that Michelle's here to do a walkthrough. So there may be some changes, especially like to the confidentiality part. Since I hear that sealing is a potential way to do this and avoid a lot of the issues that the park community. And we have to think about it a little bit, a lot to it. So anyway, yes, so we're gonna move. Is that good? I mean, if there's somebody else that we think.
As good as it's going to get.
All right, so we're gonna move to H171. Thank you, witnesses, for being here. Well, this is another proposed amendment that I don't know if I should say I'm working with Tom on, but Tom has been in the loop on to try to continue to move the needle, so to speak, on the officer involved shootings and the timing of investigations. So,
Oliver or Tom?
Your version of the last year. Yeah, it was just listed under a different day. If you go to the bills folders, I'll show also.
Now, when I'm about to have a heat stroke, Karen, that's when opening starts. You know,
all right, so.
she'll smile all the way through the heat stroke. It's awful. No, not Karen. Karen would.
Oh, yeah. So
Karen would try to call 911 maybe.
So we're looking at H171, draft number 1.1, committee amendment, this would be get there, because it's in our possession. And this is a follow-up for the testimony we had a couple weeks back on offsite shooting and the way too long investigations that are occurring and all the problems that that's bringing. As a next step, we kind of felt that we were also hearing that there isn't really a protocol. We are live in.
Sorry.
So we thought establishing, it's one of the things we heard is isn't really a protocol or standard, someplace to look in legislation statute to understand what's supposed to be happening, why are things taking so long, et cetera. So this is actually something to get at that. With that, I'll turn this over to John.
Right. So for the record, Michelle Childs, Office of Legislative Counsel. And as the chair mentioned, we're looking at an amendment to H171. So replacing, it's a strike all amendment, replacing the language with, it's not a, I want to call it a working group. Sometimes when you just have like a little handful of folks who are your usual suspects in the room and who you work with, direct them to do a little work and come back to you with a proposal. So you'll see creates a new section 1 on officer involved shooting protocol. And I'll mention, don't know if you had mentioned to the committee earlier. So this was kind of a collaboration between the folks who are designated in subsection A around how to do this. So it's the Attorney General's Office, DSAS, DPS, and the Vermont Association of Chiefs of Police sort of work collaboratively to identify a protocol and best practices for independent investigations of officer involved shootings. Subsection B identifies the things that they're supposed to take a look at. So
Before you, I had a question on A, why don't you go through the bill?
okay. Subsection B are the things that they are to address. First one is to define officer involved shooting. So remember our conversation when we had done the walkthrough of the bill as introduced, and what types of incidents trigger an investigation. Define conflict of interest. So because you're thinking about it depends in a particular county, and one of the reasons why it oftentimes goes to the Attorney General's office or another county state's attorney's office is because they have close relationships with law enforcement in that county. So identify the appropriate steps to manage any conflicts for law enforcement and prosecutors. Delineate the process for informing the Attorney General's office, DSAS, of an officer-involved shooting. Identify the general steps for law enforcement investigations into an OIS. I'm starting to pick up the lingo.
That's pretty good.
Page 2, subdivision 5, describe the process for prosecutorial assessment of the investigative materials, including dual independent assessments. Number 6 is evaluate the process of investigation and prosecutorial review of, oh my God, that'll have the little acronym there. I just added that at the last minute. To ensure timely criminal charging determinations and identify and address existing barriers to timely criminal charging determinations. And then finally, outline the final outcome to an investigation and assessment of an OIS, such as clearing a law enforcement officer or filing criminal charges. Subsection C is just to say that, you know, when they're doing this work, they're to be looking at other jurisdictions to kind of see what their protocols are and see what we can learn from them. Subsection D is that on or before December 1st of this year, the entities shall submit one written report to the committees on judiciary detailing their work and agreed upon protocol for officer involved shootings and any legislative changes necessary, including appropriations to effectuate the protocol. And then I made it effective on passage and I retitled it because the bill is introduced. It's quite different. And so it would be after passage, it would be an act relating to criminal justice agency protocols for an officer involved shooting.
Oh, yeah. First of all, I like that nice small group.
I didn't even want to call it a working group.
What's that?
I said I didn't even want to call it a
Yeah, right.
When you call it a working group, everybody wants on.
So I had 5 on my mind, just because, but there's 4 here. No, and my question is around that, and I mean, I'm not, you know, married to any of the, you know, anybody in here, whether they should be in or out, but one that came to mind that I don't know if we would put them in as a fifth or maybe replace somebody else would be the Fraternal Order of Police, and only because they were here testifying the other day. I guess that's kind of an open question more to the committee than to you. If that's necessary, or are we, we're certainly covered with law enforcement. I mean, there's no doubt about that, but.
Yeah, let's ask that of the witnesses as well, what they think. I mean, I don't have one way or another, Tom.
I think it would be handy to have just a blib of legislative intent in there.
Okay, yeah.
So that we can find a resolution to resolve these in a timely fashion.
Yeah, no, that, yeah, kind of take that from the original 171. Yeah, okay, got it.
This is, I think, so not really going to the walkthrough, but I have a question on something that maybe could be included in this. So I think it's more to you. So this, I think, is great, and it kind of captures a lot of what we heard. The one thing that's missing in here, and I don't know if it's appropriate or not, would be something looking into how we can treat officers who are involved in officer-involved shootings during the investigation. I think like that was something that was pretty powerful testimony that we heard. Like they kind of like that there's concern for their mental health and their like how like what happens to them during this like long period. I understand that it's a investigation to a potential criminal charge, right? So it's a weird thing, but not touching that at all in this, if it's a working group that's like in that, like we're trying to come up with best policy for how to,
Especially if they're not charged.
yeah, well, and I don't really know what the right language is, but this is really great and it just touches on every other thing that we heard, but it doesn't really touch on that issue.
Right, so let's plan on adding those 2, but also let's hear from some of the witnesses, and we can also ask, since we have kind of a small working group already, they can help us form that language. I think they understand what we're getting at.
Yes.
We can talk to them and get to weigh in. So let's get it from, who wants to go first? Todd, why don't we start with you, Todd, since.
Thank you, Michelle.
Michelle.
Great. Great to see you all. Good afternoon. I'm glad it's 47 degrees cooler in here than it was 10 minutes ago. Yes, remarkable. For the record, Todd Delos, Assistant Attorney General. So we worked on this language. In fairness to state's attorneys, Kim got a look at the rough draft maybe in half an hour ago, maybe not even that. So I think she'll speak to her thoughts on the language. Generally, this seems like a good path forward. We appreciate the opportunity to look at it and provide a report that can at least dig into some of the issues that we touched on in the testimony 2 weeks ago. I'm happy to kind of, as far as talking about union representation on this, I guess what I would say from a prosecutor's perspective, again, we're looking at potential criminal violations, and certainly the chiefs of police and the sheriffs and the state police make sense because they're doing some of the measure of the investigation into it. I'm not sure where the union's role in the process of investigating union members. It doesn't seem to make sense to me.
Right.
The mental health piece is really, sorry.
No, so Tom and Karen.
Me?
Yeah, Tom and Karen.
So, just one thing I learned through this process was that the department doesn't really have a huge responsibility to the officer, typically. So I think somebody should, whether it's union or not, or some sort of ID, represent them, be good.
Yeah, I think that's I don't disagree that certainly for me as just a person, that was really powerful testimony, right? About the mental health supports that need to be there when folks' entire careers are on the line, for the most part, doing the hardest part of their job they'll ever have to do. That's completely heard. And I guess I would just suggest to the committee, if this group is working on the protocol for investigation, I'm not sure putting both together will make the most sense. There may be overlap, and I know it'll probably be more than 5, but there could be value in, we wouldn't necessarily have a role in that. I'm not sure. Well, I'm happy to hear other thoughts on it, but our investigation, our analysis of the investigation and determination of charges isn't necessarily going to engage with law enforcement, right? But the state police would certainly have thoughts on that, the sheriffs and the chiefs. And I only suggest it's a little bit of, the two are very clearly related, and I'm not sure the work streams are necessarily dovetailed. And again, I just want to my frame of reference for it, for what it's worth to the committee, is this is a criminal investigation. And that's how we are going to look at what we're doing here. There's a timeliness issue that's well heard, and I think that's going to be addressed in this work because we're taking people off the street potentially who should be getting back to work in a timely manner.
Yes. I don't know if you were done, but I have a question, so maybe it just can be incorporated. I appreciate this. I feel like, put the people together, figure out a plan. And I appreciate the piece that this is a criminal investigation, but let's work on the timing and kind of make sure that all the players are being communicated. In that, I have concerns, and I haven't fully thought it out why I have concerns, but we're victim voices in this. And I know that would be a part of the Attorney General and the Department of State's attorney. There's victim advocates, but I feel like that's a voice that's missing of how are we making sure that this is timely and working for all the players, but that the victim who is the result of this criminal invest is also being considered.
Yeah, I really appreciate that. And I think I want to be thoughtful. I know that our process, and Kim can speak to the process for the state's attorneys, involves victim input and engagement with, I think some of the really powerful testimony you heard from the families in early February, no idea, but it was this year, we were able to talk to them and sort of share kind of our process. And that was, I think, helpful. That would be incorporated in kind of this conversation. But again, we have that process for victim input in our general criminal investigations. And I want to make sure that I keep being clear,
what is being asked of us is to create a protocol in one type of criminal investigation that we don't really have those protocols, and we don't have written protocols in all the other types of investigations. And I think we want to hew as closely as we can to the work that we do here, with an understanding that there are other concerns that this committee has with how those investigations are moving forward.
So I'm hearing it's already baked into how you do the work. And I feel like I can trust this current players, but I guess I just want to make sure that whatever protocol is created is taking into consideration that. So I don't know if language is needed, but I'm just hearing that that's already baked into your protocol and process is helpful. I'm just flagging that.
So Todd, I'm really glad you said what you did, because I certainly appreciated what Representative Rhoda was saying. I was thinking about the perception that I've heard from families of victims who have said, oh, they always find law enforcement not guilty, and question if it is going to be a truly non-biased investigation. And anything that slants that, and we're worried about the mental health of officers, seems like that would perpetuate that myth. And the sooner that the investigation happen, the easier it will be on people's mental health. But I know that, in trying to do my own research, I'm like, why would these take a long time? They can be complicated with witnesses, etc. So I like it being sort of single focused, trying to figure out how to best do the kind of investigation that needs to happen, and figuring out how to support victims and law enforcement in other venues.
The question.
I guess there wasn't. Sorry.
That's fine. Yeah, I just wanted to make sure that you were done. Ian.
Yeah, it's fine. I'm happy to. I'll talk about it once we're done.
So cut that out as a video.
I think the most important part is we find a way to do this timely, and that will be the healthiest thing for the officers are. And then it will be up to their agencies to help the officers out, although some smaller agencies aren't going to have a clue until it's happened, what a disaster it is going to be for their employee. And maybe if there's just some input somehow, or control or mandated protocol.
Ian does want to ask a question.
I think basically, and do you agree with my question is, there's no protocol right now on this. We're trying to establish protocol. Let me finish. And part of the reality is the lack of clarity on how this works has a impact on officers who are involved in officer-involved shootings. And so if we're creating a group of people to look at establishing clear protocol on how this works, I think it just makes sense that as an element of one of the things to look at should be something that we look at, which is how those officers are, how are they treated and involved during the process? Because it is a criminal investigation, but until they're charged, they are not. They're still state employees or local employees, and it's there's something. It just feels like it would be a real. It would be a part of this that we're not looking at if we're building a group to look at this full process. Because that's my question. Would you agree with that?
Compound question.
Yeah.
So let me start with, there is a protocol process. Okay. It is not distilled in the way that I think is sought here. And so that's understood, and that's something we're happy to work on. Again, I would just caution that I'm not aware of other instances in criminal investigations where a defendant in the prosecutor's line of sight is, you are obviously thinking about somebody's health and well-being, and I'm not sure that's deeply considered. I would agree with Rep. Oliver's statement that, speed will be certainly helpful. probably a distillation of process will be helpful. But the third point of sort of, and the agencies need to understand it, and there may be a space for that. I would just say from where we sit, we want to be really careful about crossing that boundary, because we want to be, the whole point is for public trust, for the well-being of the victim's family, and for the ultimately a clear determination for the officer, which usually is getting them back to work.
We do every day take into consideration defendants in the courtroom to be have as little impact on them as humanly possible.
And thank you for that. I would say, I'm not sure it's in any kind of process manual, but you would, fuck it.
So, kind of playing off what Representative Rachelson said, and there's been victims that have had concerns and, not the exact comment, but the cops always get off type thing. So considering the current AG, past AGs, or potentially future AGs, or thinking about state's attorneys, and I don't expect you to speak for the state's attorneys, but through an investigation, I gotta believe that if you come to the determination that a crime was committed, it's gonna be prosecuted, plain and simple.
Absolutely. And I will say the AG herself, the current AG, reads all of these 30, 50, 80-page reports that she gets.
Yeah.
And makes that determination herself.
Okay. Any other questions? Kim, I think we're gonna have.
Sorry, Karen.
Who's the brother's name?
I'm sure I made the decision myself.
Jump in too.
Oh, yeah, right now.
More to come.
Okay, thank you.
Thank you all.
Give him a cookie.